This morning we have Mr. Brendan Brown, and may he be sworn.
Please state your full name.
My name is Brendan Craig McMahon Brown, but people know me as Brendan Brown.
Please take the book in your raised hand and repeat after me. I swear by Almighty God.
I swear by Almighty God.
That the evidence I shall give.
That the evidence I shall give.
Shall be the truth.
Shall be the truth.
The whole truth.
The whole truth.
And nothing but the truth.
And nothing but the truth.
Yes.
Before I start asking you questions, I understand that you would like to put on record a correction to paragraph 243 of your first witness statement, and you would like to replace the words non-exempt status from tax to just saying exempt status. Is that correct?
That's correct.
You are the Director of Citizen Services at the NHS Business Services Authority. Is that right?
That's right.
And you've held that post since the 1st of September 2017.
Yes.
And it's NHS BSA, as I'm going to refer to it,
Sure.
was chosen by the Department of Health and Social Care to run the English Infected Blood Support Scheme, or IBS. Why was NHS BSA chosen for to run IBS?
The department officials might have to answer that question rather than myself. We were directed as NHS BSA are to deliver many services on behalf of the department and the Secretary of State, but it was their decision to direct us to be the scheme administrator for EBS.
And you yourself have been involved with EBS from its inception, is that right?
That's right.
You were involved in the consultation process between the Department of Health and Social Care and the Alliance House organisations about the establishment of EBS.
Yes, that's right.
And then you held the role of project executive during the setup of EBS and oversaw the project board and had overall responsibility for setting up EBS.
That's right.
What, as a Director of Citizen Services at NHS BSA, what is your current role with in relation to EBS? What do you actually do?
Sure. Perhaps putting things into context, my role is far-reaching in terms of having responsibility or accountability for all of our citizen services. So there's round about 1,300 colleagues in total delivering a whole range of different citizen services, from a shared services contact centre to the Overseas Health Service, which includes the European Health Insurance Card Scheme, NHS Student Services, one of the smaller schemes, and a team of round about 7 colleagues who are supporting me delivering EBS. But it's a very varied mixture of services that we operate for the public.
And so you have responsibility, do you, at the NHS BSA for EBS?
I do.
And you say that there are 7 colleagues delivering the EBS service. Can you just give us a broad outline of who they are and what their roles are? Is there a manager, assistants, and so on?
Yeah, sure. So the team members are assessors who deal with beneficiaries, deal with calls, emails, and written correspondence. They also process the applications that come in and ensure that all the payments that we make are accurately processed. The team also has a team manager overseeing them in terms of making sure that the work is cleared, that it's accurate, that we are delivering our KPIs and delivering our SLA that we have with the department. Above that, there is a senior service delivery manager as well, who not only has responsibility for EBS, but also has responsibility for some other teams as well. And they ultimately report into a head of service who reports into me. And I have 7 heads of service for reporting into me.
And what we've heard from evidence from the other schemes over the week, and it seems to be that the staff have stayed in post quite a long time, often from the beginning of the setup of the schemes. What's the turnover of staff like at EBS?
Very, very low. The attrition is very low. I mean, the team are absolutely dedicated to the work that they do. Some people, have through succession and have had opportunities for promotion, but the turnover is very, very low.
What did you understand about the suffering of those infected with hepatitis C and HIV from contaminated blood when you first became involved with EBS?
I was aware from the general media at the time. When I first had meetings with the departmental officials, they provided me with some background as well. And in time, I then met with Jan Barlow and some of the trustees from Alliance House organisations. And then once it had been announced publicly by the Minister, Jackie Doyle-Price, that NHS BSA would be directed in England to be the scheme administrator, I attended a PPG meeting to answer questions and reassure beneficiaries what the transfer would be like, and stayed back and listened and heard firsthand some very upsetting events and that people had lived through.
And has your knowledge changed over the years that you've been involved with EBS?
It's only deepened in terms of my knowledge over time. Obviously, working and talking to the specialist team who deal with beneficiaries, and continuing to be interested in the infected and affected communities. I can only, I'm almost lost for words really to describe how individuals were treated and have been affected and will continue to be affected for the rest of their lives, and that is upsetting. So I've got to make sure that the team we have working in EBS are accessible and do everything that we can to make sure that the payments and other support that we offer is given, and we continue to deliver that as best as we possibly can.
Just to set the evidence we're going to hear this morning in context, in terms of the size of EBS, are you able to tell us how many beneficiaries there are on the books, as it were, at the moment?
There are just under 2,100 beneficiaries. 3,100 beneficiaries at the moment that we're supporting in England.
We know from your witness statement that you've had just short of 5,200 applications to deal with at the point that you wrote your witness statement. Is that right?
Yes.
And if I just give you those figures and ask you if these are correct, that EBS have approved 4,000, or at the time you wrote your witness statement anyway, EBS had approved 4,458 applications. They declined 549, and there was further information required in 192 applications. Is that correct?
That's correct.
And of those declined applications, those 549, is it right to understand that those encompass both applications for people coming onto the scheme, i.e. people saying, I'm eligible for payments, and applications brought by people already on the scheme, already beneficiaries, perhaps for discretionary payments, or perhaps to get increased payments because of their conditions deteriorated and so on.
That's correct.
I'm going to ask you some questions now about relationships with beneficiaries and identifying beneficiaries. So I'm going to start with relationships with beneficiaries. Is it right to understand that the main forum for engaging with beneficiaries is through I think what you've described in your witness statements as ad hoc focus groups?
That's right. We do organise focus groups. We've had to move them online because of COVID, but yes, that is the main focus in terms of the EBS team engaging with directly with beneficiaries.
And what's the purpose of those meetings?
The main purpose is to update beneficiaries on where we are and how well the service is operating and performing. Also to listen and take on board any aspects that any of the beneficiaries feel there's opportunities for us to review or improve, and it's a way of us collecting a range of insights firsthand from beneficiaries.
And how is the agenda for such meetings set? Is it people turn up and bring up what they want, or is it more formal than that? There's
an element of formality to it in terms of there being a structure to them, but we always give plenty of opportunity so individuals can raise with us items that they feel weren't covered in the within the set agenda. Sometimes it might be around someone might have a strong view in terms of an experience they'd had, good or otherwise, and they wanted to be shared and heard by the focus group so that we can learn from it. And sometimes it might simply be that in terms of the next focus group, they're suggesting a topic for discussion.
And in terms of the structured agenda, what items are on the structured agenda?
So on the structured agenda, we tend to be quite transparent in terms of how the service is operating in terms of the number of beneficiaries, some of the volumes that you've just covered off. It might be around discussing form design or access to the service in terms of is it easily accessible. There's nothing that can't be on. What I'm trying to say is there's nothing that can't be on the agenda. It's partly driven by beneficiaries and partly driven by ourselves as the scheme administrators.
And is it right that these meetings take place every 2 to 3 months?
That's right.
And pre-pandemic were around the country?
That's right.
And how are beneficiaries invited to those meetings?
I don't know that level of detail, I'm afraid. I can possibly follow that up with you, but as my team organise them, I wouldn't want to mislead the inquiry on that.
It's perhaps not a very well put question. Really, what I'm getting at is I understand from your statement that it's not a focus group that where there is a set membership. It's on a rotating basis.
That's right.
So you would get different people to come to all the different meetings.
We would definitely want to encourage a blend of views coming through, so that all beneficiaries at some time would have the chance to join, whether that's just to listen and watch and observe, or whether it's to contribute and share their perspectives with us.
And are those meetings minuted? Do you know?
They are.
And are those minutes made public?
To my knowledge, they are. But again, I'd have to confirm that with you. There's certainly no reason why they shouldn't be, because there's nothing that isn't that's discussed there that we wouldn't share.
Is this right, that the information that's gained from those meetings by EBES is fed back in a formal sense to the Department of Health and Social Care through the Joint Review Group?
That's right.
And the Joint Review Group is a decision-making forum looking at the scheme rules that the Department of Health and Social Care and EBES attend on a regular basis.
That's right.
Are beneficiaries, to your knowledge, are beneficiaries aware that is the process, that anything they raise in the focus group will then be taken through to the Department of Health and Social Care?
In terms of if they are raising something that they wish to be considered and changed within the scheme rules, then to my knowledge, we would reassure them that would be taken forward to the Joint Review Group and would be discussed with the departmental officials.
And is there a way of feeding back the outcome of their of what's fed to the Department of Health and Social Care back through to the particular beneficiary that raised it?
Well, we also produce newsletters, which can include elements of updates as well, where we would be if it was a specific query. As an example, we may go back to that individual and update them. So that would be the normal process that would be followed. It could possibly be carried forward in terms of the next group as well, so that we're continuing to share back to the focus group, the outcome from the discussions with the department.
Although, of course, may not be the same
Absolutely.
membership of the group. What would you say the benefit are of the meetings we're talking about, the focus group meetings?
Well, the benefit to ourselves as scheme administrators is to ensure that that we are not operating the scheme in isolation of beneficiaries. We believe we are performing well and meeting the required standards that have been set for us by the departmental officials who've directed us and are funding us to operate that scheme. But ultimately, if the beneficiaries hold a different view to that, it's important that we listen, take on board any feedback that they have, and either correct something if and we have done. We've made adjustments to some online content or forms particularly, or if it's something that's more policy related, and it often is, then that would be something which we would take to the department for consideration.
Is there a reason why there isn't a beneficiary or on the Joint Review Group, which is the decision-making body to look at all of these aspects?
I don't know why there isn't one single beneficiary sort of representing the entire. There's probably no reason why not, and it might be something to take away and consider. There's nothing that we discuss that we wouldn't be happy for a beneficiary to be party to, and particularly now that we're doing things more virtually, it's far easier. So I will certainly take that away, and I can see no reason why a beneficiary wouldn't be able to join.
You've mentioned that you have another way of communicating with beneficiaries is through newsletter, and of course there is also the website. There's reference in the paper to the papers that have been provided to the inquiry to a satisfaction survey being considered. Was that ever sent to beneficiaries? We
undertook a satisfaction survey in March of 19. because of COVID, that wasn't repeated in terms of in 2020. However, we did undertake a survey of the newsletter, but we had previously had some feedback from beneficiaries around not wanting to be overly surveyed. So it's a balance for us around, seeking people's views through the focus groups and doing surveys, we are now working on a new survey that we plan to issue later in the summer or early autumn after we've made the parity payments.
I'm going to ask you some questions now about work done to identify new beneficiaries. And if you've been listening to the evidence this week, you will have heard that all of the schemes to date, all of the schemes that have given evidence so far have said that they were not given information by the Alliance House organisations about applicants who had applied to the Alliance House organisations and had been rejected. Is that the case for IBS as well?
That's right.
So presumably you're not able to contact those applicants individually. What would IBS's response be to an application from such an applicant?
If an applicant had applied to us and had made a historical application, we would consider it on its merits. It would follow the same process as a new application. We may need to seek through the Alliance House appointed lawyer to their legal firm, but it will be considered on its own merits, the same as any other claim.
Has IBS taken any steps to engage with that cohort of potential applicants? It's difficult for us because we don't know who they are. Alliance House knew. What we did do, and it might be helpful for me to explain, when IBS was established, two of the staff that were former Alliance House employees were seconded back to Alliance House for around 6 months to actively pursue individuals who were held in their records, hadn't given consent, or make people aware of the new IBS scheme. So we carried the cost of that, and we seconded these people to Alliance House to carry out that activity. We also work with helper organisations in terms of Terence Higgins Trust and Hepatitis C Trust and Haemophilia Trust to make people aware through their networks of the England Infected Blood Scheme, as well as on our website. And obviously the DHSC consultation was quite broadly covered in the media as well. So there were other elements that have happened, but unfortunately we do not have direct access, despite trying, at various times. Certainly in the whilst the Alliance House team were still there, suggesting ways in which people may be reached. And you were mentioning there the work done by the staff being seconded to the Alliance House organisations to identify beneficiaries on their scheme. Are you there primarily talking about the 460 people who were beneficiaries of the Alliance House organisations and had not given explicit consent for their details to be passed over to IBS?
That was the primary purpose, but there was no, we gave the resource to Alliance House for them to use to enable, any potential beneficiary of IBS to be alerted, signposted, and supported to come to the EVE scheme.
And of those 460 beneficiaries who were effectively lost on transfer, is it right to understand that 67 of those have actually come forward and have been accepted onto the scheme by
That's correct.
by IBS?
That's correct.
And as part of that process, your witness statement suggests that what happens is that you get contacted by one of these, I'm going to call them lost beneficiaries,
Okay.
ones that are lost on transfer, and you require them to contact Russell Cook to get the data that Russell Cook, the solicitors for the Alliance House organisations, hold sent to you. Is that the process?
That's right.
Why do you do that? Why is it that way round rather than you contacting Russell Cook yourself and asking for the information?
Well, partly we've looked at this and in terms of expediting the process, the fastest way is for the beneficiary to instruct Russell Cook themselves, because Russell Cook needs to be satisfied that it is the individual that they are dealing with, it is their record. The records naturally contain confidential information. Russell Cook can clarify what information will be divulged to NHS BSA and also reassure them when that has actually happened. So we found, after considering the different routes to it, that was the better and quickest route. What we do find is that if one of this cohort approached us and we signposted them to Russell Cook and then there was a delay in us getting anything, then we would revert back to that individual just to make sure if we could help them in any way, get Russell Cook to to release that information to us.
And you say in your witness statement that you've got some plans for a future communication campaign to try and publicise IBS. Can you just tell us what the plan is for that and how you're going to try and get hold of potential applicants?
There are a few options that have been put forward to the Department of Health, and that was in March of this year. It's a range of communications and marketing activities, raising awareness of EBS as a scheme, and who we are, what we give out. It's intended to both reach helper organisations, but all people, clinical and professional people in the NHS who might be working with some of these people or know their conditions, and therefore might be able to support them and encourage them to come forward and apply to EBS. We're waiting for that to be signed off. It'll have to be funded by the department. It's not within our current, we aren't directed to do that as part of we are the scheme administrator. But I'm confident that the officials and the relevant minister will be minded to support that.
And why has such a campaign not been undertaken previously?
Again, that might be one more for you to validate with the department. As a scheme administrator, we will undertake anything that is asked of us in terms of operating the scheme that is needed in the same way we're busy now working on the parity payments as an example. So as the scheme evolves, if in time there is a new compensatory framework and we're directed to administer that, we will adjust and we will we'll implement that.
Does EBS do any kind of analysis to understand whether there are any gaps in the beneficiary cohort? So, particular patients that if there are no patients, for example, who have registered with EABS who were infected through sickle cell treatment or treatment for thalassemia, is that an analysis that EABS would undertake?
No, that isn't. We don't collect that information. The only information that we collect from any beneficiary is information that we need to determine their eligibility to the EABS schemes. So we don't collect those conditions as part of the application process because it isn't needed. And in terms of GDPR, it wouldn't be appropriate for us to be seeking more information from beneficiaries than we actually need in order to determine their eligibility and the level of payment that they're entitled to or the support that they can access.
Just picking up then on what you were speaking about earlier to try and understand a little bit more about the division of roles, if I can put it that way, between Department of Health and Social Care and EABS. We've heard from the other schemes that, putting it very bluntly, the government sets the policy and the scheme implements the policy that the government has set. From what you've described to us this morning, is that also the case for EABS?
Yes. I mean, England is a devolved authority as well as the other nations. So Department of Health determine the policy and provide the funding, and we operate the scheme as directed. We can see, and we'll come on to it a little bit later this morning, that the department has commissioned EABS to review discretionary payments and to make policy recommendations. Does and so we'll come and look at that in due course, but does EABS have a wider remit to suggest policy changes to the department, or is it very much reacting to what the department asks EABS to do? If I can answer, it's both in reality. So we have to comply with the instruction in terms of our directions and the terms of business that we operate by. But we are able to, because we are working with beneficiaries and like the Joint Review Group, we are able to make suggestions in terms of how policy officials may want and where we believe strongly some aspects of the scheme need to be refined or payment levels increased. But ultimately, it isn't our decision. All we can do is share the insight that we collect, the experience that we have demonstrated through through the experiences that we have, and then ultimately the department officials, and sometimes it may have to go to a minister for decision.
And does the department consult EABS when making policy decisions? And I'll just the changes that were announced at the end of March 2021, use that as an example. Were EABS consulted about the substantive changes by the department?
We were aware that the department and the other devolved nations were exploring. We weren't consulted in any huge aspect on that particular point, and in fact we were only made aware of the final details that were published the day before they were published, which was unfortunate because we had beneficiaries immediately after it was being published, naturally contacting us, seeking absolute clarity, and for many, when will the backdated payments be made? And we didn't. We were still working through the detail ourselves in terms of the parity changes.
I'm going to now ask you some questions about applications from new applicants coming onto the scheme. And I think it's probably helpful to just look at the sort of key document, the service specification, which is at WITN 4688 006. You can see at the top here it says DHSS specification for EBS version 2, August 2018, and it sets out the purpose of the scheme. And then if we go down to para 1.3, it identifies a primary beneficiary as someone who was infected directly from NHS supplied blood or blood products, or someone who was infected directly from someone who was. And then it describes a secondary beneficiary as being a bereaved partner or spouse or dependent child of a primary beneficiary. And then it sets out what the main components of the service are: to assess new applications from applicants for scheme registration against the eligibility criteria in Annex A, administer payments, annual payments, administer lump sum payments, assess applications under the special category mechanism, administer discretionary payments, with some elements to be means tested by NHS BSA. And then I won't run through the others. I'm just going to draw your attention to some of the provisions in this document while we've got it up, and then come back and ask you some more detailed questions about it. If we can turn then to page 3, just as we go through the document, we can see at the bottom there is a note. It says, based on approximately 15 new people with hepatitis C apply each year. However, this number may be higher due to increased publicity around the consultation. Anticipates about 40, and 2 new HIV applications are received per year. I don't know if you know the answer to this, but do those estimates turn out to be roughly right?
I don't know for certain. I couldn't answer specifically on that.
And then if we turn over the page to page 4, there's a requirement at para 3.1.5 at the top there for NHS BSA to engage experts in both hepatitis C and HIV who will assess the initial applications to join the scheme and the applications to progress to payments for hepatitis C stage 2 and for the SCM applications. And then we can see at the note at the bottom of 3.1.8, there's an estimation that there are approximately 60 individuals progressing to stage 2, but that may reduce slightly. And then at the bottom of that page, we see the obligations in terms of the appeal mechanisms. So for NHS BSA, to ensure the appeal mechanism is easy to follow, and this requires the NHS BSA to establish the process, including the criteria and the relevant panels and boards with adequately qualified personnel who will make the decisions. And then at the bottom of that paragraph it says DHSC will reserve a right of veto over appointment of personnel to all the boards. And then if we go over the page to 3.1.15, we can see the provision there that relates to the administration of a one-off lump sum payment to individuals whose partner or spouse or primary beneficiary, when they passed away and were infected with HIV where the infection with HIV and or hepatitis C contributed to their death. And it requires the NHS BSA to administer payments in accordance with a policy that will be published by the Department of Health and Social Care. And I'll come back to ask you some questions about that. And then we get on to the section about discretionary payments. And again, I'm going to ask you some questions about that. But just for the moment, can I ask you to look at, just understand how the funding for that works? If we see 3.2.1, DHSC will notify the NHS BSA at the start of each financial year of the maximum amount of funds available for discretionary payments in that financial year. And the discretionary budget will therefore need to be carefully managed in the year by NHS BSA. Is it right to understand that there is a budget for discretionary payments which effectively the EBS can't exceed? There's no ability to go back to the Department of Health and say, actually, we've had a run on one-off grants for this reason. We're going to exceed the budget. Can you give us some more?
the relationship that we have with the department, if the allocation, budget allocation, was likely to be exceeded, we would definitely revert to the department and seek additional funding. The discretionary applications are not limited by any cap. And one of the things, just to reassure the inquiry, that I insisted on putting in place, the individuals who consider discretionary applications have no awareness of the amount of discretionary budget to date or forecast for the rest of the year that may be remaining. That is a management decision. Their decision in terms of determining and calibrating within the team whether to award a discretionary payment or not is in no way influenced by the amount of funding that discretionary claim would impact on the discretionary budget.
So, just to make sure I understand that, what you're saying is that the members of the team who are assessing
Yes.
an application for a discretionary one-off grant will not know whether or not actually you're about to run out, you're about to get to the top of the budget.
Absolutely.
So that will not factor into their decision.
Absolutely, they have no idea, and the same actually applies in terms of and you might come on to it later in terms of, the medical assessors as well. They have no regard to the level of spend to date or forecast for the remainder of the year. I was adamant that if we are going to properly and fairly consider the applications, it should never be influenced by how much money is left. That should not be a factor. That's my job and the head of services job. If we need more funding, then we can make a business case for getting more funding from the Department of Health. The people who make the decisions need to make the right decisions. And
is it right to understand from your witness statement that you've never had to do that? You have never exceeded the budget?
That's right.
But despite what's said at 3.2.1, your expectation is it that if you were to exceed the budget, that you would make the business case and you would expect it to be met?
Absolutely. I would. I'm being particularly polite here, but I would be very noisy if that was the case, and that was forcing. I can't imagine the relationship we have with the departmental officials. If we had a run on discretionary cases that could be justified, I'm sure they would support it.
And then just looking then back at the specification, 3.2.3, NHS BSA shall means test applications for discretionary support against set criteria, which NHS BSA will set with the agreement of DHSC, and make the payment if applicable and funds are available. And then the next paragraph down sets out what the purpose of the discretionary support is, and we'll come back to that, but it's to provide additional time-limited financial and non-financial support to the primary and secondary beneficiaries in order to address, secondly, immediate needs, and then such needs are considered as those that have a direct effect on an individual's independence. So that seems to be the third criteria, effect on individual independence, have been brought about as a result of their infection or treatment, fourth criteria there, and then fifth criteria, and are otherwise unable to be met.
Yes.
And then if we go over we see right at the last sentence there, following elements should be included in the discretionary support system. And if we go over the page, we see a bullet point list, which includes travel and accommodation, prescriptions, means-tested grants for dealing with unexpected and immediate problems and acute events or health problems which are difficult or impossible to plan for, and where support is not available elsewhere, so mobility, shelter, home adaptations, repairs and respite. income top-ups, winter fuel payments, funeral-related expenses, means-tested supplementary support for orphan dependents and dependent children, or those in full-time education under the age of 21, and then a range of non-financial support and signposting to the welfare, NHS social care and wider welfare system, financial management advice and support, career and education advice and coaching, counselling and emotional support. And then going down the paragraphs, and I'm not going to look at these in any detail, but there's the obligation there for the NHS BSA to carry out the review of the discretionary support previously received by beneficiaries from the Alliance House organisations, and to provide a report in relation to that. And I say we'll come on to that a little bit later on. And then if we can look now then at Annex A, which is what sets out the eligibility criteria, and that's at page 14, page 14. We can see their eligibility criteria, and we'll just look at the one for those with hepatitis C, although there are parallel provisions for those with HIV. And we can see for a first stage payment, it says what the lump sum payment is, and then says in order to receive it, the individual must have been infected in England or overseas if the infection occurred while serving in the armed forces, with hepatitis C through treatment with NHS blood or blood products prior to September 91, or have acquired it from someone who was. So just pausing there, the criteria here is for if you're infected in England,
Yes.
then you are eligible for IBS.
Yes.
Are you aware of the fact that the criteria in Scotland is based not on place of infection but on residence? Is that something that you were aware of?
Yes.
And have you come across a case that effectively falls between the two? So it would have to be somebody who is infected in Scotland but is living in England. Has a case like that come across your desk?
Not across my desk. It may have been discussed by the team manager or the service lead, but not come to me in terms of escalation for finding resolution. So if it had come up, I'm assuming a resolution was found.
And then turning back then to the eligibility criteria, all applications should be assessed on the balance of probabilities of whether NHS blood or blood products used in treatment in England, except for those in the armed forces, were the source of infection. And again, we'll come back to that when we look at the application process itself. Seamus, you can take that document down. The only point I just wanted to raise with you before we look at the application process itself, it was just to pick up a point that you have mentioned in your witness statement about anti-D and the criteria for those who say that they have been infected with hepatitis C as a result of anti-D. And you tell us in your witness statement that you used to exclude all applicants who were alleged that was the source of their infection, whether or not the anti-D had been administered to them intramuscularly or via the intravenous route. But that has changed recently, hasn't it?
It has.
And why has that changed?
On the basis of medical advice that came forward, that was shared with the department, and we sought their agreement in terms of that aspect of the scheme being, allowing for those changes.
So the new criteria, as I understand it, is this correct? That if somebody has been administered anti-D via the intravenous route, they could still be accepted onto the scheme if they were able to fulfil the criteria that we've just looked at. But the if somebody has been administered anti-D via the intramuscular route, then the view of the department, and so therefore IBS, is that that is not a treatment that would give rise to a risk of being infected with hepatitis C.
That's my understanding.
So turning then to the application process itself, can you give us a bit of detail on the kind of assistance that this staff can give applicants when they first make contact with IBS to say, I want to make an application?
Yes, sure. We will discuss with the individual whether they would want us to send them the application form for them to complete and explain the supporting information and evidence that they need, whether they'd like help from the team to complete the form, although it'll still have to be sent out for the declaration to be signed and for the evidence that they collect to be submitted with the application. We try and identify what works best for the individual, for the potential applicant to the scheme, and then work with them in terms of enabling that route, recognising that some individuals have a preference for full support from the EBS team, and others are more than happy to know that they've got the right form and happy to complete it themselves.
We've heard, the inquiry's heard evidence that a significant problem for people applying to the schemes now is the difficulty in getting hold of medical records from so many years ago. I understand from your witness statement that the procedure at IBS is to signpost the applicant to the relevant places to get the records themselves. Is that correct?
It is.
And we've heard from the other scheme witnesses from the devolved schemes that certainly, so we heard yesterday from Wales, for example, that in fact that is work that the scheme will do themselves on behalf of the applicant, so they will actually make attempts to try and find the medical records themselves. Is that something that EBS ever does?
No. We would simply signpost the individual to where they could get that. We wouldn't take on that responsibility and act on behalf of the applicant to collect that information, recognising that it is personal, confidential medical records, and so our view is that the individual themselves is best placed to pursue that.
And I think possibly the answer to my question is in what you just said. But why is it that EBS don't do that?
It's certainly not part of our scope in terms of what we were set up to do. It's certainly not come through any of the research that we've done in terms of the focus groups and other activities, that it's a failing on our part. So it's certainly never come to me as something that I need to explore with the department officials to allow us to have that responsibility to broaden our scope as the scheme administrator.
Turning then to who assesses the applications, is it right to understand that clinicians, and we looked at the specification,
yes,
which placed an obligation on the NHS BSA to have clinicians to assess these applications.
Yes.
So those clinicians assess what you call as the medical-based applications, which
yes,
I understand to be the applications for special category mechanism and the applications to move from hepatitis C stage 1 to hepatitis C stage 2. So those applications are assessed by the medical clinicians, is
that's
that
right.
correct? Do they also assess the applications for new people coming onto the scheme?
They do.
And then the IBS staff assess the non-medical based applications, and so that would include applications for discretionary one-off grants or for income top-ups.
That's right. Would you allow me to just, because I think it might be beneficial for the inquiry to have an appreciation, perhaps, particularly with the medical assessments when they are undertaken. We have a panel of medical experts who consider the applications. When an application comes in, the same application is issued to two separate medical experts to make a decision on independently of each other. If they both come back and concur with the same decision, and that could be the balanced probability yes or no. If they come back with a differing view, so the two medical assessors one comes with a probability of yes and one comes back with a probability of no, it then goes to a third medical assessor and they make the final decision on whether it's yes or no. And I was very keen on putting that in place. It isn't something which happens, perhaps it isn't clear in the statement. I wouldn't want people to think that we have a team of medical assessors sat in a room all together just going through, and these are done independently to absolutely ensure that the right independent decisions are made, whether or not for them to qualify.
And your statement tells us that the current medical assessors are Dr. Bassendine and Dr. Belinda Smith, who are both hepatologists.
Yes.
Dr. Grelier, who, as I understand it, is a gastroenterologist, is that correct?
Yes.
And then a Dr. Catherine Smith. Do you know what specialism she has?
Off the top of my head, I don't know. I can revert with that level of detail for the inquiry.
Do you, is the expectation that they will determine the applications themselves rather than go to and seek information and advice from other clinical colleagues?
That's right. So they will base it. They may revert to ourselves and say that they want some further information. Something may not be clear, but they will make the decision on the balance of probability on the statement that's been declared and the evidence that's provided.
Is there a concern at EBS that perhaps asking those questions of hepatologists may not be the most sensible route? So, for example, if they're looking at an application that comes in because it's said in 1981 that there was an orthopaedic surgery that required blood, that going to a hepatologist is not going to get you is not going to get you the best information about whether or not it's clinically plausible that surgery would have required blood.
Recognising that they are expert clinicians and they are making a balanced probability judgment, and that there are two medical assessors making that assessment, with the option to go to a third if they disagree in terms of their conclusion. We haven't found that the scenario that you've set out as being an issue. It would be something that we would review, and if the medical assessors themselves, as an example, said that we are getting we are getting applications that we are unable to make a clinical judgment on, then we'd have to consider the panel membership.
So unless the clinicians said, actually, we don't think we can give you a proper answer on this,
that's right,
then you would accept whatever
yes.
what they come back with. We saw from the specification and from your answers that they are applying the balance of probabilities test. Is any guidance issued to the clinicians as to how to apply the test?
It is without taking up too much time, but in broadest sense, as long as a 51% probability is that the infection occurred through contaminated blood or blood products, that's all they need to reach. They don't. It's not any more than that. As long as they can satisfy themselves clinically, from a medical perspective, and reach a decision on the balance, and it's 51%, then that is sufficient, and we accept that.
We heard yesterday from Wales and that they apply what's called the benefit of the doubt principle. So where an application's hanging in the balance, so you might say it's actually a 50-50 application, then they give the applicant the benefit of the doubt. Is that a principle that's applied by IBS?
I'm not aware of any cases in England that have been so tight in terms of both clinicians reaching a point that it was right on the 50% point in terms of being unable to make a decision and needing to apply that principle. If that was the case, then we may have to explore that the same option as Wales has outlined, but it's never occurred in England.
And it doesn't form part of the guidance that's given to the clinicians.
But if it happened, it would be something which we would revert to the department and say, we believe this has happened. The probability and likelihood of this happening more, and therefore, it needs. We need some greater flexibility, possibly.
And has IBS, or indeed, do you know whether any of the clinicians have obtained any information or evidence on historic practices in, for example, different specialisms or in different parts of the country?
Could you? Sorry, I'm not sure what exactly.
Many of the applications, the clinicians are being asked to make judgments on whether or not a particular treatment in many years ago, often, well, always actually,
yes.
Would have led to whether it's clinically plausible that blood or blood products would have been required. Do you know whether EBS or indeed the clinicians have taken steps to obtain any information or evidence about the historic practices that may have been used in orthopaedic surgery in particular parts of the country or particular specialisms?
I'm not aware myself. That's not to say they haven't. That might be something we can revert in terms of clarity in a further Rule 9 request.
Is it right to understand that in practice, really, if somebody doesn't have medical records that show the treatment that they say caused their infection, and so the assessing clinicians are having to make an assessment about whether or not that's clinically plausible. Right. In practice, is that assessment in those circumstances determinative of the application? In other words, could an application survive and be accepted onto the scheme in the absence of medical records, and if the clinical assessors took the view that it was clinically implausible that the treatment would have required blood or blood products?
If the independent clinicians that are our assessors reached that, the two had reached, two of the three had reached that decision, then yes, whatever their decision is, that will be the outcome for that application.
So there's a range of other information and evidence that the applicant could and presumably do provide. For example, a first-hand witness statement about what happened, perhaps supporting witness statements from family members, photographs of the scar or whatever it is.
Absolutely.
That sort of additional evidence. But in light of no medical records and clinical implausibility, it's right, is it, that those other bits of evidence aren't going to be enough to get you over the line?
That's right.
Are applicants given a copy of the advice from the clinical assessors?
Not, as I understand it, not routinely, although individuals are entitled to have access to any information that we hold, and many do request, particularly where in the event of a decision being rejected, it partly maybe to support their appeal, I'm not aware that we've had many beneficiaries who've been successful also wanting to have a copy, but if they wanted to, they're absolutely within their rights to have access to any information that we hold.
So when EBS turns down an applicant, what information would be passed on to them about the clinical assessors? Would they be told that assessment had taken place in a broad outline but not a copy of the advice, or what would they be told?
You're right in the first part of your question. They would get a summary in terms of why, but not the full contemporaneous detailed notes of the file. They'd get a summary. In some cases, some individuals will come, as I've said, will come back and ask for that to be clarified, because they may not understand precisely what's being given in the summary, and some will inevitably request the full set of notes to help them with their appeal.
And would you agree with me that as a matter of principle, even if one's not giving the actual advice documents that have been provided by the clinical assessors, what needs to be given to the applicant is enough information so that they understand the decision that's been made and the reasons for it, and so they can understand what case they would have to meet if they were to appeal. That's
right. And it's also, just to add, the other key part of the determination letter is explaining how they can appeal that decision as well, which is just as important as the outcome of understanding why it's been rejected. But if they wish to appeal, we make sure that's included in the determination.
And then before I come on to look at the special category mechanism, what approach does EBS take as a matter of generality to applications from those with histories of intravenous drug use? Is a history of intravenous drug use effectively fatal for an application? Does it make it very difficult? What's the approach?
It clearly makes it more difficult for the medical assessors to make a judgment. It may be one element of the details in the case that they are considering, but ultimately that is for the medical assessor to determine whether the infection was caused through contaminated NHS blood or blood product, or through another route.
So it's not fatal to the application.
No.
It's a question of balancing what is the more likely route of infection.
Absolutely. And that as well will depend on the level of evidence that can be provided, the additional statements. You mentioned the photographs, and we talk through with and spend time with applicants, supporting them in terms of building up, an application, if it is in one of those cases, in order that the dominant factor isn't intravenous drug use as being the main purpose. That we try and support them to produce a balanced application.
I'm just going to turn then to the special category mechanism. Can we look first of all at the form itself, which is RLIT 40650. So you can see on the front of the form that this is an application for the SCM application form. Just find my paper version. And there's some guidance there set out on the first few pages, which I'm not going to take you to. Can we turn just then on to page 5 of the form? which is just sets out that applicants' detail and contact preferences. And then if we turn through then to page 8, just to get an idea of what's required for somebody filling out this form. So they've got to set out whether they have any of the conditions that are listed, and then at the bottom the doctor has to confirm the information that's been given in section 5A. If we go then over to the following page, please, Shamik. Section 6A to be completed by you if you do not have any of the listed conditions in 5. And then the applicant's asked to provide information on how their infection or its treatment and possible complications affect their daily living. It has 2 questions which ask about whether the impact of your hepatitis C or its treatment affects your ability to carry out daily activities because of A, mental health problems, or B, chronic fatigue. And you have to answer at least one of the questions. The first question being, does your hepatitis C infection or its treatment make it difficult for you to carry out daily activities such as leaving your home, using public transport or shopping, etc., as a result of mental health problems, such as feeling depressed or anxious? And then you say yes or no, and then you say how often, and then you must say, and then please say how substantial the impact is on your ability to carry out day-to-day activities. So that's the first question. And then at the bottom of the page, there's the second question, which asks, does your hepatitis C infection or its treatment make it difficult for you to carry out regular daily activities such as walking, climbing stairs, etc., cooking, as a result of feeling chronically fatigued? And again, yes or no, set out how often, and then over the page, you need to set out how it impacts on your, how substantial the impact is on your ability to carry out those matters. And then we get to section 6B, which is to be completed by the doctor. And then so the doctor must confirm that the hepatitis C infection is making it difficult for them to carry out regular daily activities as a result of mental health problems, and then state which mental health problems, how long they've been suffering from them, a duration, the expected duration, and if there's any treatment, what that is. And then it says, in your opinion, how likely is it that your patient's mental health problems are attributable to their hepatitis C infection or its treatment or effects? And then the doctor is given 4 choices: not likely, possible, highly likely, and definite, and then an opportunity in the box below to give more information. And over the page we see the equivalent question asked of the doctor in relation to the second question asked of the applicant about chronic fatigue. So again, state how long it's been going on, and then make a statement about the causation of the chronic fatigue and being caused by the hepatitis C being attributable. Again, choices are not likely, possible, highly likely, and definite. And then over the page, there's an overall clinical opinion asked of the doctor or the nurse. Please confirm that in your clinical judgment it's likely that your patient's hepatitis C infection or its treatment or complications is having a substantial and long-term adverse impact on their ability to carry out daily activities. And again, they've got the 4 choices: not likely, possible, highly likely, and definite, and then a box for the clinical assessment in words. So that is the form that needs to be filled out.
Yes.
And then can I take you then to WITN 4688006, which is the specification that we looked at earlier. Which sets out at Annex C what NHS BSA is expected to do. So that's at page 17, please. And so if we can actually go over to page 18, which gives you the direction to us about assessing the application, and it's in section 6 and section 7 that I'm interested in drawing to your attention. So it says here, it's under section 6. In this section, the individual and their medical practitioner should be providing evidence of a substantial and long-term impact. Where the medical practitioner ticks not likely and the information provided confirms this, the application would not generally be passed. Where the medical practitioner ticks highly likely or definite and the information provided confirms this, the application would generally be passed. And then equivalent provisions are set out below section 7. We don't need to look at them, but the same is said for the section 7, which is, of course, the overall clinical opinion that the doctor is being asked to apply. Shemit, you can take that down. The guidance from the department is silent on what EBS is supposed to do if the box possible is ticked. What does EBS do if the box possible is ticked?
If possible is ticked, the team will make a judgment in terms of good cause, looking at the evidence, both the statement provided by the applicant and by the medical statement. They will also look at previous statements in terms of calibrating that against earlier SEM applications as well, and come to a judgment on that, with a view that we always try wherever possible to see if something has perhaps been missed that would enable the individual to get the help that is available for them. It isn't designed in any way to sort of try and reject more applications. It's just a way of closely scrutinising and finding a way of being able to justify that the individual meets the criteria for the higher payment.
Is the test that the EBS is applying the balance of probabilities?
No, it's good cause. So in here we're applying. It's different in terms of considering the information that's being stated. It is a judgment in terms of, but it isn't restricted by the 51% example that I said earlier. As long as we are satisfied that sufficient good cause has been demonstrated, then we would make the decision. I can understand your questioning, but this isn't an area where we have seen a large number of rejected applications and people then wishing to challenge the decision. So it's never operated as a it's never come forward as a problem for us. I haven't got the details with me. Perhaps in a if you so desired to have it, we could possibly analyse all the records to see how many actual applicants in fact tick that box. But off the top of my head, I don't know that.
So when you say that the test you're applying is good cause, is it right to understand that the test is there good cause to believe that it's likely that the hepatitis C infection is having a substantial and long-term impact on their ability to carry out daily activities? Exactly. That's the test, is it?
That's the test.
And so you assess good cause. Is that not a percentage basis?
It's based on each case is considered on its own merits in terms of what has been presented in the application. It's influenced by the statement, obviously validated by the clinician, and then the individual who's making that assessor who's making that judgment. They would calibrate their decision with other team members, and that would have to go to the team member to be verified and signed off as well on these cases as well.
But if one's looking at what good cause actually means, so we understand what the balance of probabilities
Yes.
means, because we understand about percentages and we understand it means more likely than not. But if one's looking at good cause, could a case be successful even if somebody thought, well, actually, on the balance of probabilities, I think there's less than a 50% chance that this person's hepatitis C infection is having a substantial and long-term impact on their ability to carry out daily activities. But because the test is good cause, that's sufficient.
That chance, I guess, could exist. But we have a signed declaration from the individual outlining how the infection is impacting on their life. We have aspects, or all of it, verified and validated by a clinician as well, that their health is declining, certainly gone beyond stage 1, and that is likely to be sufficient in terms of satisfying the SCM. It's clearly not a stage 2 payment, but it's a sufficient to say that it's a broad. There's a broad. How can I describe this? There's a broad aspect of being eligible in terms of eligibility. Some people may be beginning to have their health declining. It's worse than stage 1, and there'll be others who apply who have severely, or the health has declined, and it's an easier decision. What we don't want to do is just reject people and keep people at stage 1 when clearly there is some evidence that their health is declining and it is impacting on their life.
So is it right to understand that really the test that you're applying and the phrase good cause really relates to the fact that there is evidence that has been produced by the applicant that is supported by their clinician, and so it's really a very light touch assessment in terms of how the strength of that evidence. If that evidence has been produced, that would be sufficient to give you good cause to conclude that
That's
there
right.
has been the test is made out.
Yes.
Is that the way that it's
Yes.
approached? I'm conscious of the time, and I've gone on rather a long time. Just a couple more questions on this topic, and then perhaps it'd be a good time to break. We've heard evidence from Wales and Scotland about the benefits of having a self-certification process, i.e. not involving clinicians at all. Is that something that that has been considered by EBS and discussed with the Department of Health and Social Care?
It's none of the discussions I've been involved in have involved that. The model, as I've described earlier, seems to be working, and particularly and why I took the time to explain how we use the medical assessors as well, to ensure and to validate the decision. So it's nothing that the discussion that there may be a discussion happening in the department, but it's not one that I've been party to.
So that was, in fact, the only question I had left on the SCM.
Well, I just have one matter to raise before we do take a break. It really is because of the wording of good cause to believe that infection has a substantial long-term impact on normal day-to-day activities. That phrase, a substantial impact on, I think the word normal doesn't appear in the form, but it does in the Equality Act. It's almost a direct lift in drafting from the way in which disability is regarded or defined in the Equality Act. And there have been particular problems, or were particular problems in the past, they've been ironed out by case law, in knowing what substantial meant and what day-to-day activities might encompass. And it was established that the focus was not on what people could do, but what they couldn't do, because that was a point of contention. But then the question is substantial. Is there any guidance which you give to the medical assessors or to the applicant as to what substantial means? Because in the context of the assessment of disability in the Equality Act, it doesn't involve a wide judgment on the spectrum, saying if you're halfway along the spectrum or over that you're substantial. It's a much simpler question of, is it not insubstantial, not merely trivial? If it's any more than that, it's substantial.
So I wasn't involved in terms of myself personally involved when the guidance was written with the department for establishing the medical assessors and their judgment, or the EBS team in terms of the SCM that we've just discussed. So I would need to come back to you on that particular question rather than give my own opinion rather than it being factually based. But hopefully I've given an honest and transparent view that the way in which we operate SCM particularly, which was the last set of questions, that we are working with beneficiaries and understand that their health will decline over time, and if they are able to access the SCM payment, it is not our job to stop them and block them and pay out less money. It's to support them.
And what you've been telling me, I think, is in effect that although I've raised what might be regarded as a theoretical point, it hasn't actually, as far as you know, affected the decision in any particular case.
Absolutely. It's again, SCM cases. I'm not aware in terms of them being rejected. We often do revert back to the applicant if we believe that a more detailed statement might help from them, or if something's unclear. The basis that we are working with them is to be absolutely clear that if we're going to say that there isn't any good cause, we want it to be absolutely clear and no doubt at all that there is no good cause, and that the health has not actually declined. And I'm not aware of any cases that have come through where we've rejected it because of on that basis.
Well, thank you very much. We'll take a break. We'll come back at 12. I'll say to you what I say to all witnesses who are giving evidence when we come to a break. You're giving evidence. What you must not do is talk about the evidence you have given or you think you may yet have to give with anyone, whoever they are, but you can talk about anything else you like.
Okay.
I'll see you back at
Thank you,
12.
sir.